Hello, everyone. Thank you for joining with us today. Welcome to the first day of our third international workshop. Today's topic is the Dispute Prevention Resolution Continuum. My name is Nujat Tasnim, and before starting, I would like to tell you about Mediate Guru, as some of you are new here. So, Mediate Guru is the social organization led by members across the globe. Our aim is to bridge the gap between general public and litigation by spreading awareness about mediation as the future. We have conducted various international webinars and events with speakers from all around the world so that you can add value to your legal career. So without further ado, let me introduce you to our speaker, Miss Reshma Oogorah. Miss is the founder of Niyom Legal, an innovative legal consultancy focusing on dispute prevention and resolution. She is the Solicitor and Barrister admitted to practice law in England and Wales. She is also a fellow of the Chartered Institute of Arbitrators. Ma'am has been involved in resolution of high-value disputes, including of mega construction projects and major oil and gas companies in Middle East. So I would like to welcome Ms. Reshma to take the stage and share her knowledge with us. And please remember, everyone, that you can ask your questions in the chat box. We'd like to make this session as interactive as possible. Feedback form will be sent at the end of the session. And now I would like Ms. Reshma to start her presentation. Thank you.
Good evening, everyone. Thank you very much, Nujat, for that lovely and kind introduction. I hope that you can all hear me. I'm very delighted to be here with you this evening. Thank you so much for choosing to be with us on this workshop tonight. And we hope that we'll be happy that you did. I would also like to congratulate and commend the organizers, Mediate Guru, and in particular, Param, Garima, Aditya, and Nujat for working relentlessly to bring you these webinars and workshops and for widely promoting mediation and ADR methods as a means to avoid disputes. And that really helps people to get a quicker, more efficient, and cheaper resolution to their disputes. Now, without any delay, let me share my screen with you. Right. All right. Well, our topic for today is the dispute resolution and prevention continuum. And the idea behind this topic actually is to present you to the different techniques that businesses may use to prevent, avoid, and resolve disputes at different stages of their contracts and their projects. As many of you may know, I do a lot of dispute prevention, avoidance, and resolution work in the construction sector. So today's discussion may revolve to some extent around construction projects. And I've spent many years resolving disputes when they have reached the courts and arbitration. And while some disputes do settle at that stage, my observation is that many such disputes could have been settled at an earlier stage or prevented altogether. My hope is that this workshop will help you, whether as a business, as professionals, and future professionals, to develop more awareness and take positive steps towards dispute prevention and dispute avoidance to avoid the costs, time, and stress associated with fully fledged disputes in court or in arbitration. Right, so without further ado, let's look at our agenda for today. Firstly, we'll be going back to basics and rethink the definition of a dispute. What is a dispute? At which point can we say that a dispute has arisen? Secondly, we'll talk about whether, and if so, why disputes are an issue. Why should organizations avoid disputes? Thirdly, we'll look at dispute prevention and the different dispute prevention methods, followed by dispute avoidance and dispute avoidance methods in the fourth part of this workshop. And finally, we'll discuss dispute resolution as the dispute resolution methods and the dispute resolution methods available. And by then, we would have created and gone over what I call the Dispute Prevention Resolution Continuum, or the DPR Continuum. And at the end, I'll also be answering your questions. And please feel free to post your questions and comments as I present. And hopefully Nojad will be taking notes of your questions and I will answer them at the end. If ever I don't get to answer your questions today, I'll collect them and send you a note afterwards. Right. So, disputes. What is a dispute? A dispute exists when two parties differ in their position regarding an entitlement under a contract or the law, and they are unable to arrive at an amicable solution to resolve the situation. So basically, this is where one party thinks that it is entitled to something from the other party. And in businesses or in business, most of the time, it is money or some form of payment. And the other party takes the view that the first party is not entitled to that thing or money and refuses to pay it. An additional point for a dispute to exist is that the parties cannot agree and find a solution to their conflict or disagreement amongst themselves. And that's the point where one might think that the parties have a dispute. Now, you just heard me use a few terms. I've used disputes, I've used conflict and disagreement. And you may have heard of other terms which indicate a dispute, and you may think that those terms are similar to a dispute, which is why I thought that it would be interesting to flag a few of them here for discussion. And there are three terms that I would like to discuss. There are dispute, conflict, and claim. Before we dive into this, let's see what you think. Can you type in the chat box to let us know if you think that a dispute and a claim are the same? Or if you think that a dispute and a conflict are the same? Or if you think that a dispute, a conflict, and a claim are the same? Or if you think that neither a dispute, nor a conflict, nor a claim is the same? I think that the answer to this question would depend on the context, but generally, I think that we will all agree that anywhere you find human beings, you'll find conflicting opinions. And conflicting opinions are not necessarily a bad thing. Actually, they can be a good thing. Differences in opinions can help us to grow, both individually and in teams. I can see that Shrishtika has responded and she thinks that disputes and conflicts are the same. There's many of you that have now responded and think that it's four. And you think that neither of them is the same. All right. Awesome. Thank you very much for your responses and for making this interactive. I really appreciate it. Yes, so many of you think it's four. Neither a dispute, nor a conflict, nor a claim is the same. All right. So what I was saying, I was actually talking about conflict, and I was saying that wherever you find human beings, you'll find conflicts because we all have differing opinions, and that can be a good thing. And having differing opinions can also help us to find better solutions and outperform what's expected. And effectively, conflicts can lead to positive outcomes for both parties. However, a problem arises when instead of converging to a positive outcome, conflicting opinions actually diverge and escalate into disputes, which then go to arbitration or litigation. How about a claim? Well, the concept of a claim is usually used in the construction industry as meaning something specific, and it also has a specific role to play. So, for example, when a contractor thinks that the owner of a project owes it something that can be an extension of time to complete the project, or more money because the contractor has had to do more work than was originally envisaged. In that situation, a contractor would submit what we call a claim to the owner to ask for these entitlements, or to somebody that has been appointed by the owner. And then the owner or someone on behalf of the owner would assess the claim and decide whether the contractor should get it or not. And like a conflict, a claim may also escalate into arbitration or litigation. Now, to illustrate this point further, I would like to share this with you. This is a continuum, which is a risk, conflict, and dispute continuum model, which was published by Acharya and Lee in an article which addressed the conflicting issues in construction projects from a Korean perspective. And the authors, among whom were Acharya and Lee, designed this infographic to address the issues of risks, conflicts, claims, and dispute. And as you can see, what this infographic is effectively communicating to us is that risks, which is most likely a reference to contractual risks, risks which are not clearly assigned to the parties in a contract leads to conflict. Conflicts which are not clearly managed lead to claims, and claims which are not clearly resolved lead to disputes. So these authors effectively made a difference between conflicts, claims, and disputes. And from the image here, it appears that disputes are more serious than conflicts or claims. Right, so now moving on to the second part of today's workshop. Why are disputes an issue for businesses? Well, in the construction industry, for example, it's quite common to have a few unresolved claims or disputes at the end of a construction project. Well, again, let's see what you think. Can you type in the chat box if you think that disputes are an issue? Yes or no? Please type yes if you think that disputes are an issue, and please type no if you think that disputes are not an issue.
Many of them are typing. Is just there is a difference of time in 30 seconds. That's why the chat is showing.
All right. Thank you for letting me know, Nujat. That's very helpful. I can see that people are still responding for the first question that I raised in the chat box. Thank you. Thank you so much for sharing your views. All right. I can see you typing. Please keep them coming. But please also respond to whether you think that disputes are an issue. Yes or no? Do you think that disputes are an issue?
Yes, most of them are saying yes.
Okay. All right. Awesome. Right. Okay. Well, if most of you are saying yes, it seems that you don't need to be convinced that disputes are an issue. But even so, let's look at why they can be an issue and an impediment to doing business. Well, first of all, I'd like to talk to you about performance and quality. When there is a dispute, as we just saw, that's a situation where the parties to a contract have a conflict, which they cannot resolve by themselves. So when there's a dispute, a project or contract may come to a halt or may get delayed. Employees tend to have a low morale, which may further contribute to these delays or the stopping of the works. We often see that parties and their employees may be so affected that they do not perform the work up to the quality or the standard that is expected due to the ongoing dispute. For example, if a contractor on a project is not being paid due to a dispute, it may not feel particularly motivated to do its best work. Cost. This is a very obvious one because dealing with a dispute can be costly. Parties have to spend money on avoiding or resolving a dispute. They will need to allocate a budget for expert fees, lawyers' fees, court fees, arbitrators' fees, or institution fees, etc., etc. Well, resources. Well, when a dispute arises, instead of working on the business and doing what they do best, a business will need to redivert some of its resources to resolving the dispute. For example, people who are involved in the project and have first-hand knowledge of the dispute will need to spend time with a professional team hired to resolve the dispute. And on a construction dispute, for example, that may mean that the project manager may be taken offside, or the commercial manager and even the CEO may need to interrupt his or her work to dedicate time to prepare the case, and even testifying at court or at a hearing in arbitration, which is usually not something they were hired to do in the first place. Well, stress. As you can imagine, the whole dispute situation can be stressful for the people involved and for whom it is not their day-to-day job. It can be very challenging. It can be a very challenging experience to be questioned or cross-examined by lawyers and be involved in a dispute process altogether. And ultimately, all these factors, performance, quality, cost, deviation of resources, and stress affect a business's bottom line or its profits, right? Well, disputes may have a negative impact on a business's profitability. All right. Well, let's try to make this more interactive. This time, we're not typing in the chat box. There will be a poll, and I'll pass on to Najat, who will be conducting this poll. And I really encourage you all to vote. Yes, there's many of you on the workshop today. So the technical side is following. It will be up soon. Meanwhile, maybe you could type in the chat where you are calling in from today. It would be great to know whereabouts you're based. I'm calling in from Saudi Arabia today.
Miss, most of them voted for poor contract management.
Poor contract management. All right. Well, thank you very much. Thank you very much for your answers and for participating. I wanted to share this survey with you if you haven't already read it. It's the Queen Mary University in London and the Pinsent Mason, which is an international law firm, recently conducted a survey in 2019 on international arbitration, which was aimed at driving efficiency in international construction disputes. And one of the questions asked to the respondents of that survey was whether in their experience in the last 5 years, what were the common causes of international construction disputes? And approximately 63% said that it's late performance. Approximately 61% said that it was poor contract management. 60% said that it was poor contract drafting. And 24% said that it was defective materials. Just going back. So, Nuja, did you say that most people had voted for poor contract management?
Yes, ma'am, 43%.
43%. Okay, so as you can, if you wanted to compare, 61% from the survey said that it was poor contract management. All right, so now that we have an understanding of what disputes are and why they are an issue, I hope that, I'm sorry, I was just putting my video on. Yes, I hope that you would agree with me that we should prevent them from arising and also prepare for ourselves when they cannot be prevented. And this takes us to the next part of today's workshop, which are dispute strategies. Well, as I mentioned at the beginning of this workshop, firstly, we prevent disputes. That is, we stop them from arising altogether. Secondly, if they have arisen, then we should do our best to avoid them. And I personally make a distinction between dispute prevention and dispute avoidance, because for me, the prevention of something actually means that one is thinking and implementing strategies which will stop that thing from happening, in the sense that it doesn't already exist. But in contrast to that, when you avoid something, in my view, it means that the thing that you're avoiding is actually already in existence, and you are thinking and implementing strategies to mitigate its effects or to make it go away. And in the dispute context, my view is that we prevent a dispute when there is actually no dispute in existence, and we are effectively deploying strategies to prevent disputes from arising altogether. Whereas in the case of dispute avoidance, a dispute already exists, and we are deploying strategies to avoid an escalation, to mitigate its effects, or have it resolved amicably before it develops into a fully fledged dispute. Well, having seen all the disputes that I think could have been prevented or avoided, I think that businesses can really make more efforts to implement dispute prevention and dispute avoidance strategies to avoid the cost, the time, and the stress which are usually associated with a fully fledged dispute. And then thirdly, after prevention and avoidance, we'll be talking about dispute resolution methods. And that's where you have a fully fledged dispute and amicable resolution methods have failed. And now you have no choice but to actively deploy formal dispute resolution methods to avoid it. All right. So dispute prevention. Like I mentioned before, when we talk about prevention, we are talking about employing effective strategies to prevent disputes from arising altogether. To a large extent, this requires us to have sufficient experience or to have learned from the experience of others in handling or being involved in disputes. And that would equip us with an understanding of what works and what doesn't work, so that we can effectively deploy the strategies to prevent them from arising. Now, what might those strategies be? In my view, there are many different dispute prevention strategies which can be deployed. And for the sake of today's workshop, I have placed them in 3 groups at the different stages of a project or a contract. So firstly, we'll be talking about strategies at the contractual stage, and then the operational stage, and finally at the conflict management stage. Right, so let's begin with the contractual stage. Well, in my view, the contractual stage begins as soon as when the scope of works or the contract is being implemented. And by that, I mean what the paying party in a contract is expecting the other person to do. And the best protection against conflicts or disputes is to, of course, have a contract in the first place so that the parties can establish their relationship. And secondly, to ensure that the contract and any documents associated with it are clear and complete, that each party has a clear understanding of their rights and obligations, as well as the consequences of breach of the contract. In my experience, many construction and even commercial disputes arise because the contractual documents were not sufficiently clear. For example, a party may have omitted to list out a few items that it expects the other person to do on the project, or they have a different understanding of what a particular term means in a contract. For that reason, there are particular aspects that I would suggest one focuses on when preparing the contractual documents to prevent disputes. The first of them is to allocate risks clearly and fairly. And really what that means is to identify who's going to be responsible for what and to spell that out clearly in the contract. And examples of risks may be a natural calamity or a pandemic like the one we're experiencing right now with COVID, delays, strikes, etc. And the contract should clearly spell out who becomes responsible or bears the loss if such a situation arises. Parties should also aim to have a fair equilibrium in a contract to avoid having one party feeling as if they made a bad bargain by entering into this contract, and which then becomes a challenge and leads to conflicts or disputes. The second point I wanted to talk about is payment. A contract really should have clear payment mechanisms, and that would involve spelling out clearly who pays who, how much should be paid, when, and by what means, whether by check or bank transfer, and also whether there are any preconditions to making payment. Thirdly, variations. Well, that's the mechanism for making any changes to the contract or the scope of works, and this should be, like I said, spelled out clearly in the contract. And then we have the dispute resolution clause or the dispute resolution provision in the contract, which I think should be given special attention and should be drafted in a way to encourage dispute prevention and avoidance strategies before resorting to court action or arbitration. Of course, if that's the party's choice. A dispute resolution clause can ideally specifically state that the parties should engage in amicable settlement discussion, have a mediation process, etc., before taking any escalation action to go to court or to arbitration. And finally, collaborative working is one aspect that I would ask parties to consider when devising dispute prevention strategies at the contractual stage. I think that parties should find ways to encourage collaboration between themselves so that they work together as partners as opposed to against each other, as can often be the case in construction projects. And this may be done by having partnering arrangements or joint ventures where each party's compensation is linked to the completion of the project. And there are actually a lot of standard contracts in the construction industry which support and encourage that now. Well, we now move on to dispute prevention at the operation stage. So assuming that we have prepared clear and fair contracts at the contractual stage, it is now up to the performers of the contract to take action to further the dispute prevention initiatives. Well, features that may help prevent disputes at the operation stage are firstly, good management of the project. There's actually a very informative guidance note issued by the Royal Institution of Chartered Surveyors, abbreviated as the RICS, which many of you may know of. And if you're interested in reading further about this, please let me know and I will share a copy with you. The guidance note actually talks about good management in many different spheres, such as project management, client management, constructor management, design team management, and so on. And essentially, this boils down to having a consistent application of the contract and good communication amongst the various parties involved. And also good processes to follow while implementing the contract. And that should be both on-site and off-site in the context of a construction project. It should also include regular reporting and proactivity on all sides in the contract. I can see that many of you have now responded with regards to my question, to the question I asked earlier. Whereabouts are you calling from? So I can see many of you calling from India, Lebanon, Saudi Arabia, Riyadh, Kuwait again, India. That's awesome. Abuja, Nigeria, Bangladesh, Namibia, Lagos, Nigeria. Awesome. London, Zambia. Great. Very, very happy to have you all here. So we've covered management now in terms of a dispute prevention strategy at the operation stage, sorry. Secondly, have good payment practices. There is a saying in French that says "Les bons comptes font de bons amis," which means good accounts make good friends. And in the context of business and construction projects, I would translate that, or I would adapt that to mean that good payment practices help keep friendly relationships. Having good payment practices can really avoid animosity, conflict, and dispute, as parties focus their energy on doing the work that they were hired to do instead of having to spend time and resources on chasing payments. Thirdly, record keeping. Well, good report keeping can prevent disputes. And that means keeping a well-organized and accessible record of documents and information, for example, on labor, accessing the site, plant, materials, resource movement, and some record of when change occurs on a project. And as well as being a good dispute prevention strategy, good record keeping can also help in dispute avoidance and dispute resolution. Well, so the third stage of dispute prevention, I think, would be at the conflict stage. And as we saw earlier, that's a stage where there still isn't a dispute, but more of a difference in opinion which can have positive impacts on your business or project. And there are different strategies that one can adopt at that stage to prevent a conflict from turning into a dispute. And one strategy might be clarification, and that would entail the clarification of the issue which forms the subject matter of the conflict by both parties. And really, it's about communicating the issues clearly, which can help to de-escalate the conflict and prevent the conflict from escalating into a dispute. If clarification does not serve to de-escalate, it is advisable to engage in early stages of soft negotiation techniques, which focus on preserving the business relationship between the parties. And negotiation is essentially a process where the parties in conflict or disagreement, claim, or dispute engage in discussions to resolve any disputes that have arisen between them. And they may also hire a third party to negotiate on their behalf. There are different types of negotiation techniques and approaches that can be adopted depending on at what stage of the conflict or dispute you're at. And here I would note that negotiation is actually a technique that one can use at any stage of the dispute, at the different stage in addressing a dispute. So it can be at the prevention stage, at the avoidance stage, or at the resolution stage, because parties can settle at any stage. So this was it about dispute prevention and the different strategies in ensuring dispute prevention. I really hope that you will employ these dispute prevention strategies to effectively prevent disputes from arising, and that you will research further into such dispute prevention guidelines, because really that's the most critical stage which can help in saving the time, cost, and avoiding the stress associated with disputes. Now, can you type in the chat box to let us know if you will be adopting such dispute prevention strategies? Because of the time lag, I'm going to move on, but I come back to your answers. So please respond. Please tell us whether you will be proactive in adopting these dispute prevention strategies. Okay, well, we now come to the fourth part of today's workshop, and which is dispute avoidance. Well, sometimes, despite our best efforts, disputes still arise, right? And as I mentioned before, when a dispute has already arisen, we would adopt dispute avoidance strategies in attempting to avoid its escalation into a fully fledged dispute. While I was preparing this workshop, I came across this picture that you can see on this slide here, where people are practicing social distancing. And to draw an analogy of dispute avoidance with the pandemic which we are currently in right now, we are practicing social distancing and several other strategies such as restricted travel, etc., to avoid the pandemic, which is already in existence. And as far as the pandemic is concerned, I would say that we are in the pandemic avoidance stage, because if we wanted to prevent COVID from becoming a pandemic, then there is a whole set of different prevention strategies that we could have employed if only we knew that it would become so serious, right? So without commenting on whether these strategies would have been viable or not, examples of what could have been done to prevent the pandemic are, for example, stricter disease control in the country where it was first discovered, earlier border closures with that particular country to prevent COVID from spreading to other countries. Some would even argue that we could have taken better care of our environment or consumed less animals to prevent COVID. But really, we have passed the prevention stage now, and we are in the avoidance stage. Whereas I said, we are using social distancing, working from home, restricted travel, etc., to avoid the spread of the disease. And it seems that we are not yet at a stage where we can fully resolve the pandemic or free ourselves or the world from it. And perhaps the resolution stage can be achieved when we have a vaccine and when most people have been vaccinated so that we can no longer be infected with COVID anymore. Anyway, so getting back to our subject of dispute avoidance, there are many different dispute avoidance strategies that can be used, and I'll be covering 4 of them briefly today. A few things to bear in mind is that at the dispute avoidance stage, there is likely to be the involvement of a third party who may assist the parties in dispute in making a decision, but that decision may not necessarily be final or binding. Right. Well, the 4 dispute avoidance strategies that I'll be talking about are firstly negotiation, which we've already touched on briefly. I'll also be talking about neutral evaluation, mediation, and dispute boards. All these methods would normally require the intervention of a third party, except for negotiation, perhaps. And the reason dispute board is a bit disconnected and is both blue and red is because, in my view, it is more of a hybrid form of dispute strategy, as it serves both as a dispute avoidance and a dispute resolution strategy. I will go into more detail when I cover dispute boards in this workshop later on. All right, so negotiation. We've already partly covered negotiation, but just to add to what I've already said, negotiation can be conducted between the parties in a dispute, either between themselves, or they can each hire the services of a representative who would negotiate on their behalf. If it is, well, it is essentially a strategic discussion, and I'm referring to negotiation. Negotiation is effectively a strategic discussion that may help to resolve a conflict, a disagreement, a claim, or a dispute in a way that both parties find acceptable. And in dispute prevention, we say that the parties should negotiate by focusing primarily on the preservation of the parties' business relationship. And while this should continue at the dispute avoidance stage, negotiations at the dispute avoidance stage can become more technical, and each party may try to persuade the other to agree to his or her point of view on the various elements of the dispute by using statistics, data, and more sophisticated negotiation skills. There are actually different negotiation techniques and tactics that can be adopted, and generally, negotiation is a combination of skills such as communication, persuasion, planning, and strategizing. These are all skills that can be learned and applied depending on the parties involved, the type of issue at hand, culture, and what is at stake, and so on. Well, there are different school of thoughts as to how negotiations should be conducted out there. There's a lot on the internet. There are many books that have been written about it. But for today's workshop, I'll be sharing with you the 8 golden steps, which can be read in more detail on the website negotiations.com. Well, the first step that's stated in the golden steps is understanding. Each party should gain an understanding of the purpose of the negotiation by prioritizing and ranking the objectives of the negotiation. And one should not only do that for themselves, but they should also do that for the party that they'll be negotiating with. The second step is invent solution scenarios. Really, what that means is try to come up with solutions which may be acceptable to both sides. Thirdly, establish the alternatives. And in negotiation, we talk about the best alternative to a negotiated agreement, or the BATNA, which is the fallback position should a negotiation not succeed. And fourth, give your BATNA some spinach. When you strengthen your alternative to a settlement, you are effectively empowering your position at the negotiation table. A weak alternative would, on the other hand, weaken your ability to be effective in the negotiation process, where you may accept a less favorable deal. Fifth, who's the big cheese? And really what we want to know before we go into any negotiation is who has the authority to agree to a decision arising out of a negotiation. So you don't want to be in a situation where you have negotiated and you have agreed to something, but then the opposing party then tells you, oh, we have to clear this with our management or with another person who has authority. So make sure that on both sides, the decision maker is in the room or at least readily accessible in order to close the deal quickly. 6, what do you know about them? So make sure that you know the decision maker. So do your research. We say that information is power, right? So do your research about the decision maker of the other side to make your proposals as appealing to him or her as you can. 7th, don't let the bow break. And what we mean by that is remain flexible. Don't be too rigid about what you know and what you have prepared. Be open to new opportunities, adapt to the circumstances, and be willing to adjust your strategy and tactics accordingly. And finally, know your fairness yardstick. You really want to build a long-term, durable relationship with the other side, and it is important that you both feel comfortable with the deal that you're going to agree to. Because it has to be realistic, because otherwise, one of the parties may feel that they've done a bad deal, and this can be a disaster, because then later down the line, the parties may, those feelings may crop up, and there may be challenges and conflicts and disputes. Now, negotiations can be real fun if that's something you enjoy. And like with most things, preparation is really, really key before engaging in a negotiation. Well, the second dispute avoidance strategy that I would like to talk about is neutral evaluation. This is also known as early neutral evaluation or independent third-party assessment in some cases. And as the name suggests, there's a third party who is a neutral and independent, that is someone who doesn't act for either side. So that neutral is appointed to give an opinion on the dispute at hand. The parties would provide him or her with a copy of the contract and their claim, give the person access to project records and key persons on the project. And that person will thus gain a full understanding of the contractual framework and events and issues that have arisen on the project. That the neutral will then perform a detailed analysis of the contract and applicable facts and law surrounding the dispute to give his or her opinion of the contractual entitlements of the parties. And then he or she will present his or her conclusions or findings to both parties. And then that may be it. The parties will then use that evaluation to arrive at a settlement. But that person, the neutral, may also help in facilitating negotiations between the parties, who may then decide to enter into settlement agreement, and that will be the end of the dispute. But the parties have no obligation to follow the neutral person's opinion or advice, or even to settle the dispute. The third dispute avoidance strategy is mediation, and I know that you're very familiar with mediation. And as you may already know, mediation is a private process where a neutral third person, who we address as the mediator, helps the parties discuss and try to resolve the dispute. The parties have the opportunity to describe the issues, discuss their interests, understandings, and feelings to each other and to the mediator, and they also provide each other with information and explore ideas for the resolution of the dispute. The successful outcome of a mediation may be documented by the parties or the mediator in a settlement agreement. Well, I don't intend to spend too much time on the process and features of mediation today, as tomorrow, Raphael Tisblatz will be addressing you on those issues. And I would really recommend that you attend tomorrow. He will be presenting a workshop on mediating disputes and facilitating dialogue through the person-centered approach. And as I said, I highly recommend that you attend tomorrow. It's at 8 p.m. IST or 3:30 BST. All right, so we now move on to the fourth dispute avoidance strategy, which is dispute boards. This is very particular to the construction industry, but dispute boards can also be used in the context of complex contracts or projects where conflicts or disputes are likely to arise. So what exactly are dispute boards? Well, dispute boards are actually a mechanism, it's a party-agreed mechanism, which call for the appointment of one or three independent persons who are selected and appointed by the parties. And according to the International Chamber of Commerce, which issues a set of ICC dispute board rules, a dispute board, or a DB, is a standing body composed of one or three DB members, typically set up upon the signature or commencement of performance of a mid or long-term contract. They are used to help parties avoid or overcome any disagreements or disputes that arise during the implementation of the contract. Well, from the perspective of what I've just read, we can also say that in addition to being a dispute avoidance strategy, DBs can also be classified as a dispute prevention strategy, as they may act as an incentive for the parties to avoid getting into conflicting situations altogether. Dispute boards can also serve as a dispute resolution function, as they may result in a binding decision which the parties have to follow. In practice, though, the dispute board members are appointed by the parties at the beginning of a project, and they stand by in case there are any disagreements between the parties in order to resolve them so that the project can continue. DB members are most often very familiar with the type of construction involved. They are respected people in the industry, and they approach their responsibilities with neutrality and impartiality. DB members may also be called upon to have a continuous role to play by keeping track of the construction project's progress and make site visits so that they can remain up to date with how the project is evolving. I can see that some of you have responded now to my earlier question on whether you would be adopting dispute prevention strategies. And I can see that most of you who have responded are saying, yes, you will adopt them. I cannot see that anyone has said no. Thank you very much for responding. Thank you. And thank you also for adopting these dispute resolution strategies. All right. So to carry on with dispute boards, well, in terms of a process, when a conflict or dispute arises which is not resolved through negotiations or other dispute resolution, dispute avoidance mechanisms, the dispute is referred to the DB members, and the DB may or may not hold a hearing within a short period of time. And then, based on the party's preference, the DB will either render a recommendation, which is not binding in nature, or a binding decision concerning the issue in dispute. A dispute board, which only makes recommendations would be called a dispute review board, and a dispute board which makes binding decisions is called a dispute adjudication board. And under the FIDIC set of contracts, which is a standard form of contract used in the construction industry, the DB has 84 days within which to make a decision. In case the parties have agreed for the DB decision to be a binding decision, they ideally respect that decision and proceed with the project. But if they do not agree with the dispute board's decision, they can challenge the decision in arbitration later or in court if that's what they've chosen. And this is why we say that a dispute board's decision is binding on the parties, but it is not final. And this is also referred to as a pay now, argue later mechanism. Well, as you can probably gather from what we've been discussing so far, these DBs provide a fast track and real-time decision making process during a project. And early decisions allow parties to proceed with certainty and prevent the stacking up of disputes at the end of projects. All these advantages of dispute boards make for an effective dispute avoidance process. And in reality, the majority of dispute board recommendations or decisions help to fully resolve party disputes or facilitate amicable settlement by the parties themselves. Okay, so now we have a few polls, and I will again hand over to Nujat so that she can conduct them.
Yes, ma'am. Sure. I'll let you know the results.
Thank you, Nujat.
Ma'am, for this poll, people, what do you think is the success rate of dispute boards? For this poll, people voted for 75%. 44% of them voted for 75% success rate.
44% of attendants have voted for 75%.
Yes.
All right. Okay, before I get to the results, let's conduct the other poll. I thought it'd be better to combine these two together. Yes, so what do you think is the success rate of mediation?
Ma'am, 72%.
So how many, what's the percentage of respondents?
56% of people voted for 72%.
Okay. Awesome. Thank you so much for responding and for participating, everyone. Well, just to share some statistics with you, in 2019, out of 2,700 projects, 1.2% was sent to dispute boards, and these are statistics from the from a special organization which tracks dispute board appointments. So out of 2,700 projects, 1.2% was sent to dispute boards, 99% were resolved, and 85 to 98% of decisions have not gone further to arbitration or litigation. And it is thus fair to say that dispute boards have a very high successful rate of between 85 to 98%, which is very, very high, right? It's very, very effective. So when it comes to mediation, the Center for Effective Dispute Resolution, or the CEDR, reported a success rate of 89% in mediation. And this was in a survey conducted in 2018-2019. And again, this is very, very impressive. Okay, so to summarize now, we just went over 4 types of dispute avoidance strategies that parties may adopt in trying to de-escalate or to resolve their disputes amicably. They are negotiation, neutral evaluation, mediation, and dispute boards. Right. So as you are all too familiar, not all disputes can be prevented or avoided, which is why the courts exist. So there are quite a lot of conflicts or disagreements which develop into fully fledged disputes and flood the courts. And at this stage, we're going to talk about 2 types of dispute resolution methods, namely arbitration and litigation. And by litigation, I mean the resolution of disputes through the court process. The most obvious or common way to finally resolve a dispute when amicable methods do not work is through the courts. The courts is therefore the default dispute resolution mechanism applicable in any contract. Arbitration, on the other hand, is an alternative to court, which means that the parties to a contract can choose to have their disputes resolved through arbitration instead of the courts. I assume that most of you have a basic understanding of what the court is and how the court works, but anyway, I'll be going over the characteristics of the court compared to arbitration in a moment. But before that, we'll take a look at the definition for arbitration. And for those of you who attended my last webinar organized by Mediate Guru, this would be a good revision. Right? So arbitration. What is arbitration? Well, according to the Chartered Institute of Arbitrators, which is the leading training organization for dispute avoidance and dispute management. Arbitration is a non-judicial process for the settlement of disputes where an independent third party, an arbitrator, makes a binding decision. The role of an arbitrator is similar to that of a judge, though the procedures are less formal, and arbitrators are often an expert in their own right. Well, we can see from this definition that arbitration is a non-judicial process, which means that it is not conducted within the courts or by the courts. It is an extrajudicial process which is conducted privately. Secondly, arbitration involves an independent third party, that is an arbitrator. Instead of a judge or a panel of judges, it is a third party who we call an arbitrator or a panel of arbitrators who make a decision on the party's dispute. Arbitration results in a binding decision, which means that the parties generally have to accept the decision of the arbitrator or of the panel of arbitrators. And this is in contrast to the other softer means of alternative dispute resolution, which we saw earlier, and which do not result in a binding decision by a third party. Also, in arbitration, procedures are less formal, and arbitrators are often experts in their own right. We'll see those in a bit in more detail. Arbitration is used in many types of construction contracts, actually. It is very prevalent in cross-border contracts and construction contracts. And we also see arbitration in other sectors, such as the oil and gas sector, TMT, technology, media, telecommunications, and in the financial sector. Okay, so now that we have a basic understanding of what arbitration is, let's take a look at the two types of arbitration, which are ad hoc arbitration, which is administered by the parties and the local court, and institutional arbitration administered by an arbitral institution. In ad hoc arbitration, the parties decide on the rules of procedure themselves, and if they are unable to agree prior to the appointment of any arbitrator, they can ask the court's assistance to resolve any such disagreement. So, for example, in ad hoc arbitration, the parties would normally mutually agree on how to appoint the arbitrators, where to hold the arbitration, what language to use in the arbitration, and so on. And if they are unable to agree on these matters, they will refer these issues to the local court, which will decide these matters for them. In contrast to that, in an institutional arbitration, the dispute is administered by an institution, which has what we call rules of arbitration. And those rules describe the procedure to be adopted by the parties in making decisions related to their arbitration. Generally, these institutions also have a private court attached to them, to which they can turn to make any decisions prior to the appointment of arbitrators or on any issue which arbitrators do not have the authority to decide. There are many such institutions around the world, and some of them are represented here on this slide. For example, you've got the ICC, which is headquartered in Paris. In the UAE, we've got the DIC, LCIA, and the DIAC. In UK, there's the LCIA, the London Court of International Arbitration. In India, there's the Indian Council of Arbitration, and many others. In Saudi Arabia, there's the Saudi Center for Commercial Arbitration. In Mauritius, there's the Mauritius International Arbitration Center, and the MARC, which is the arbitration institution of the local Chamber of Commerce. All right. So now that, we've explored what arbitration is and the two types of arbitration. And we have an understanding of what litigation, court litigation is. Let us now compare them. Well, before we proceed, can you tell us what you think the different characteristics of arbitration and court are? For those of you who attended my webinar last time, we really have no excuse. What do you think are the characteristics of arbitration when compared to court? Please let us know in the chat box. I will continue in the meantime. All right. So the first characteristic that I would like to compare is choice versus default. So like we discussed before, court is the default mechanism for resolving a contractual dispute. However, parties can only engage in arbitration if they have contractually agreed to do so. So parties have to expressly choose to arbitrate their dispute instead of going to court. They normally do that at the time of concluding their commercial contracts by entering into an arbitration agreement. Private versus public. So as you may know, court proceedings are generally conducted in public, and this means that anyone, members of the public, can attend the court hearings and can have access to the documents submitted to the court, which are of public record. However, in arbitration, the documents of the dispute and the hearing are kept private. Arbitration hearings are conducted privately behind closed doors. And this can be at a venue dedicated to conducting arbitration hearings or another suitable venue agreed by the parties. And nowadays, due to the pandemic, arbitrations are also being conducted virtually on different technological platforms. And the court have also followed suit. The courts are also conducting hearings virtually. Choice of arbitrators versus allocation of judges. Well, in an arbitration, the parties pick the decision makers of the dispute, that is, the arbitrators, and they can pick someone they trust, irrespective of whether they are legally qualified or not. Usually, parties would pick someone who has a reputation of being neutral and fair, and also who would have a good understanding of the subject matter of the dispute. They may choose such professionals from a wide pool of professionals available worldwide, who have specific experience in the subject matter of the dispute. At court, parties are allocated a judge or a panel of judges, and they do not have much say over that. They usually have to accept the judges who are allocated to the dispute from the limited number of judges who are retained by the judiciary of the country in which the dispute is being heard. Flexibility versus rigidity. Well, in an arbitration, the process is guided by the parties' choice and their arbitration agreement. And in that arbitration agreement, they would select the rules that will govern their arbitration. Usually those rules can be quite flexible, and the parties and the arbitrators have the opportunity to further decide on how the arbitration should be conducted. So for example, they can decide when to submit pleadings, whether or not to have a document production phase, whether or not to have a hearing, whether or not to have experts, etc.
I didn't get that. Could you try again?
I'm not sure what that is. Well, for example, to continue, arbitration is also conducted in a more relaxed environment with less strict decorum than in court. So, for example, there are less formalities in an arbitration. No gavel is used. The legal representatives and the arbitrators do not really wear a court robe, etc. With the pandemic, we are really seeing the benefits of the flexibility and agility of the arbitral procedure and process where parties have a say and can influence the manner of conducting proceedings. As I said before, many hearings are being conducted remotely and virtually, and parties can freely agree on the technology to be used and the manner of giving evidence, etc. In court, the process is guided by the framework established by statute and procedural rules, which can be quite rigid and cannot generally be changed. And this is why we saw that during the worst part of the pandemic, most courts had to simply close down the majority of their activities or have taken considerable time to adopt their rules and systems to the situation. Speed versus delays. Well, generally it takes less time for a case to run its course through an arbitration process compared to a court process. In court, generally there are at least 2 levels of appeal. In arbitration, since the parties have control over the arbitral process, and in the case of institutional arbitration, the process is monitored by institution, which is focus of efficiency, and therefore it can take less time for an arbitration to go through the process, appeal rights. And generally, a party may only apply to set aside the decision of an arbitral tribunal on limited public policy grounds. There are a couple more characteristics that I wanted to mention before we close this part on characteristics of arbitration when compared to court. One of them is cost. International arbitration can be less expensive than court litigation because it takes less time and helps to achieve certain procedural efficiency, which result in cost savings. And as you may know, there is always an opportunity cost to time wasted for the courts. But increasingly, as arbitration becomes more popular, there is also a perception that it is becoming more expensive. And this is why we are increasingly seeing this concern addressed by major institutions around the world, which are reducing their fees, or there are many institutions that are being set up which focus on the cost aspect and charge less for conducting arbitrations. And with the pandemic, we're also seeing that there are many more virtual hearings, which also help to reduce costs. Technical expertise. Well, when choosing arbitrators, parties may pick someone who's technically qualified in the subject matter of the dispute. So, for example, in a construction arbitration with complex technical issues such as delay, disruption, or structural defects, parties may decide that the arbitral tribunal should constitute not only of just legal, but also construction professionals. And for example, in a case involving a complicated accounts, an accounting or finance professional may be appointed as an arbitrator. In court, parties do not really have this benefit, as judges tend to be legally qualified with substantial years of experience, but with less technical subject matter expertise. Right. So this is something I wanted to share with you in summary. So I think you would all agree with me that arbitration is not necessarily appropriate for all types of disputes. And in making a decision about whether arbitration is appropriate in a given situation, my suggestion is generally that arbitration will be more appropriate for large value disputes, which are in excess of $2 million. Which are for disputes which are highly technical or complex, for projects involving multiple stakeholders in different countries, where confidentiality is needed, and where a quick resolution is required. But they are not necessarily appropriate for low-value disputes, where there are less technicalities, where projects are simply structured, confidentiality is not required, and parties can wait for a decision. All right, and yeah, so as you can see from here, in my view, usually the higher the cost of a project, the more appropriate arbitration will be, and the lower the cost of a project, the less appropriate arbitration will be, and the more complex a project or transaction, the more suitable arbitration will be. Okay, so this was the final part of the presentation or the workshop today. But before we move on to the Q&A, let's take a final look at what we did today and consolidate our understanding through what I call the dispute prevention resolution continuum. So as you will see here, this is dispute prevention. And in this stage, in the dispute prevention stage, we went over the different stages where dispute prevention strategies could be implemented, which are in the orange circles here, namely the contractual stage, the operational stage, and the conflict management stage. And then you've got the blue circles, which address the dispute avoidance strategies, which are negotiation, mutual evaluation, and mediation. Really, negotiation can apply at any stage, like we discussed before. And then there's also dispute boards. But like I said before, dispute boards are more of a hybrid dispute strategy, as they serve both, or they serve as avoidance. They serve to avoid disputes, prevent disputes, and also resolve disputes to an extent. And finally, you've got the red circles where you have the dispute resolution strategies, which are litigation or court litigation and its alternative, arbitration. And there are a few characteristics here which apply to these different dispute strategies. So, for example, the further you go on the left, the less third-party involvement there will be. It will be less costly. There will be less control by the parties. These strategies will be less adversarial. There will be less formality involved, and they will be less adjudicative. Whereas further you go on the right-hand side, there will be more third-party involvement. They will be more costly. They will be more adversarial. There will be more formality, and they will also be more adjudicative. Well, I hope that you have found this useful. We'll now move to the Q&A session. Thank you very much for attending today. I would love to remain in touch with you all, and the best way to do that would be to connect with me on LinkedIn. And I look forward to connecting to you and to remaining in touch. I'll hand over to Nujat now. Nujat.
Thank you, Miss. Thank you, ma'am. This was a very informative session. So we have some questions. We have many questions, so we selected two.
Okay.
So may I ask?
Yes, of course, please.
Okay. So the first question is there any time period, like how long does an arbitration have to make a decision? Arbitrator have to make a decision.
Okay. Well, there is a very lawyer answer to this, in the sense that it depends. I mean, the general perspective is that an arbitration can take anywhere between 6 months to 2 years, and sometimes even 3 years to conclude. But there are many steps that are being taken to ensure that arbitrations are concluded in less time. One of them is expedited proceedings, and some institutions now have expedited proceedings in arbitration, whereby arbitrators have to make a decision within 6 months. And usually, when an arbitration begins, there will be a procedural timetable that arbitrators will issue. Well, it's a timetable that's agreed by the parties, but which is then issued by the tribunal. And that procedural timetable would actually have a timeline as to the different steps in an arbitration, and also as to how much time the arbitrators would have in order to give their decision after the final submissions in an arbitration. And in my experience, usually that's 3 months. So 3 months after the conclusion of an arbitration, arbitrators would usually give a decision.
Thank you, ma'am. So the next question is digitalization the key to solve construction issues such as dispute?
I think digitalization is the key to everything. But jokes aside, I mean, digitalization, and when we're talking about digitalization, I also thinking about technology. And technology is actually a very, very effective tool. And when we're talking about construction and digitalization, one thing that comes to mind is actually smart contracts. And I am really looking forward to someone or some organization developing. Yeah, sorry, I had a pop-up. I'm really looking forward to the development of a smart contract platform for the management of construction projects, which I feel would help avoid, prevent, and resolve disputes in the construction industry.
Thank you, ma'am. The answers were very insightful. And thank you for such a vibrant and interactive, knowledgeable session. I would also like to thank all the participants for joining us, and I would request everyone to please fill the feedback form provided in the chat box to receive your certificates.
Thank you very much, everyone. Have a lovely evening.
And don't forget to join on 21st November, our second session of the workshop. Thank you so much, and thank you.
I'll be joining on that session as well. So I look forward to seeing all of you. Have a lovely evening.
Yes, ma'am.
Bye-bye.